Hi everyone, I am Gulnur Bikmuhambedawarm and I'm here today to talk about the lessons from the tech world for aviation. In December 2025, the Supreme Court of Delaware issued a ruling in the Tesla Musk compensation case that offers a critical lesson for the aviation company boards. Just because a board made a bad corporate governance decision, that does not necessarily mean that the court will undo a 6-year-old transaction to fix it. And the lesson here is not about Elon Musk or the stock options. It's about the remedy design, remedial fairness, and the long shadow that corporate decisions cast, and how all of that directly applies to how airlines and aircraft lessors think about directors' accountability and transaction governance. So let me walk you through what happened, why it matters, and offer some of the perspectives in terms of what the boards and the directors should be thinking about right now. In terms of context, what happened is that in 2018, Tesla's board approved a massive equity compensation grant to Elon Musk, specifically 12 tranches of equity options that were tied to the company achieving certain ambitious market capitalization and operational milestones. So in January 2024, the Delaware Court of Chancery ruled that the board had breached its fiduciary duties. Specifically, the court found that the board was conflicted, key facts were hidden from the shareholders, and the entire fairness standard applied. In response to that, Tesla obtained an approval from the disinterested stakeholders for the second time with respect to the 2018 grant of options. But nevertheless, the result was the complete rescission. The compensation plan was canceled as if it never happened. So this case was appealed in the Supreme Court of Delaware, and the Supreme Court's ultimate consideration was whether or not the consequences of rescission were appropriate and equitable for the parties in the given circumstances. And in Delaware, the Supreme Court did find that the rescission was neither appropriate nor equitable because it left Musk uncompensated for 6 years of his work. Musk could not undo his efforts, and Tesla stakeholders could not return the benefits that they received. So, in addition, the Supreme Court also rejected an argument that Musk's pre-existing equity stake in Tesla could be a substitute for consideration under stock options because past consideration cannot be a basis to form a binding contract. So the Supreme Court reversed the decision and awarded nominal damages equal to $1. So I think there are several lessons in all of this for airline and lessor boards. Number one, hindsight remedies have built-in limits. Your board may have approved a transaction, a lease, a financing, a capital transaction, or an employment contract that turned out to be unfairly priced or inadequately disclosed when the times were good. But if that transaction has already performed for several years, if the benefits were already conferred, and if the value was already actually created, then the court will not cancel that transaction just to punish the past decision. In fact, the Tesla ruling says that if you sue 6 years later and if the CEO has actually performed and the company actually benefited and grew, then rescission may be off the table entirely. So for airlines and aircraft lessors, think about this in the context of leases, loan covenants, and vendor contracts that were negotiated and signed several years ago. If someone challenges a transaction on governance grounds years later after it closed, then the availability of the remedy, the rescission, will depend on whether the rescission is practical and whether the parties can be restored to their pre-deal position. And the reality is that in many cases, it's not possible to do that. So that's the first lesson we should say. And then the second lesson that I wanted to mention is that as a U.S. lawyer, as a New York lawyer, I noticed that this case was resolved by the court on the narrow ground that rescission was not an appropriate remedy. So the court has not addressed a number of issues from the lower court decision, which from a practical perspective, I think the companies should be aware of, should be mindful of going forward. And that includes the lower court skepticism toward later stage ratification of completed transactions, the importance of assessing independence of the board members who are making decisions on executive compensation, and issues around the breach of fiduciary duties by the board. So I think the key takeaway from all of that is that it's important to build strong corporate governance structures. So focus on fair dealing, full disclosure, and proper and detailed documentation of all decisions in real time. Because the tech world has just handed aviation with a playbook of what not to bet on in hindsight, and it's just use it. Thank you.